Yeah, thank you, colleague in media house, and also let me welcome also my brother, Honorable Paul Musmali, to address this important matter. And let me also start with the objective of the market, common market protocol, which is the overall object of the common market is to widen and deepen cooperation among the father states in the economic and social field for the benefit of the community in our partner state. And if you go further, like the what Honorable Paul are footing very well, this common market protocol is come with a guideline, many guidelines, which is the free movement of the goods, the free movement of the persons, the free movement of the labor, and then the right of establishment, the right of resident, and then the free movement of the service and the free movement of the capital. My brother, are putting very well. We have a lot of challenges for implementations for all the laws that are being established in the community. We pass a very good law in the level of assembly, and also the summit sent all of them, which is as a supreme act for all our community. Now, we are in this community because for the benefit of our people. If we allow now, our people are suffering. Like if I give you, for example, in 2018, when we moved this motion in this house for free movement of person, after 1 month immediately, what happened in Kenya? South Sudanese are being chased out in Kenya, which create a very big issue that they are foreigners in Kenya. I don't know how South Sudan can be a foreigner in the community. For example, let me quote His Excellency Uhuru Kenyatta. He did in 2018 also, and also he did in 2021 in February during the virtual summit held in 27. He said, "We leave all business for South Sudan to enter to Kenya, but until now there are no any implementation on that decision." Now, if you look for what happened between those three countries, Kenya, Uganda, South Sudan, majority of people who are moving to South Sudan, majority of them are trade. If you are charging those people $50, that means they are going to put those costs in the good they are taking the country, which means the price of the good are going to rise up, which is not good for our trade. Same now, South Sudan who are coming in Uganda and Kenya. Come and start. One person are coming with like five family or 6 family. They charge him $300, and every 3 months also say no, you have to cross again for renew your visa to enter the country. While they have a right of residence when they're in Uganda or in Kenya, their kids are in school, and all the labor from the primary, secondary school, and university. This which means those people are going to pay for more than 20 years. So this is issue that we cannot move like that in our community. Therefore, we agree that if the council of the minister are not serious in this matter, we are going to sue the community, and the law are very clear. It is a violation of the treaty, and it is a violation also for the common market protocol. And also even it is a violation of what? Of the mandate of the assembly.
Thank you, members of the press, for giving us this opportunity to address the people of East Africa on a very important matter of concern. That is the issue of visa fees that are charged by partner states on the citizens of East Africa, as well as work permit fees. In 2018, myself and the Ndugu Kim Gai, we moved a motion in this house urging the Council of Ministers to address the issue of visa fees charges as well as work permit fees that are charged on the people of East Africa. The then Chair Council of Ministers promised that he's going to take this matter and address it with his colleagues, and they were expected to have these visa issues addressed as well as work permit issues addressed. It is now coming to 3 years since our motion was moved, and there is no response. When you look at Article 75 of the treaty, this is about the establishment of the customs union, and I will go to sub-article 1. It says, for purpose of this chapter, the partner states agree to establish a customs union. And in establishing the customs union, they agreed to abolish unnecessary barriers to trade. These include non-tariff barriers and where they were charging, where there are tariffs that were charged. When you go to sub-article 1M, it also talks about simplification and harmonization of trade documentation and procedures. So this trade documentation and procedures include when people are moving from one country to another. They have been charging visa fees, $50. I think most of the countries have been charging $50. Mm-hmm. If Ugandan goes to South Sudan, he's charged $50. South Sudanese comes to Uganda, they have been charging the same. Now, it is only 3 countries, 5 countries, where they have not been charging citizens visa fees from citizens from those countries: Burundi, Rwanda, Uganda, Tanzania, and Kenya. If citizens from those countries are moving amongst themselves within those partner states, they are not charged visa fees, but they are charged work permit fees. If a citizen from Kenya goes to Uganda, they pay. Likewise, when they come to Tanzania, they do the same. Now, on the issue of visa fees, if someone is moving from, like I told you earlier, Uganda and South Sudan, is where there's a problem. As well as, let me say, the rest of the 5 countries and South Sudan is where there's a problem. South Sudan, all South Sudanese, when they come to any of these partner states, they are charged visa fees. And when citizens from these other 5 partner states, 3 partner states, visit South Sudan, they are also charged. That is Kenyans, Ugandans, and Burundians. To make matters worse, Burundi has waived off visa fees on the South Sudanese. But when the people of Burundi go visit South Sudan or go to trade in South Sudan, they are charged fees. You can see how ridiculous it is. So our motion was to abolish all visa fees charges, all charges on visas, when citizens are either trading or visiting either of the partner states. But this one has not been done. In addition, we also wanted partner states to abolish work permit fees. They can provide a documentation if someone is coming from a different partner state and is entering another partner state. They can provide some documentation, but not to charge them. They have been charging and we want this matter addressed, because given the problems that we are going through of COVID-19 pandemic, it has already disrupted trade, and then the partner states are again disrupting it more with more charges. They make it very, very expensive, and even at times very difficult for members of the community, citizens of this community, to trade freely. The East African, the Common Market Protocol also provides for free movement of people, goods, capital, establishment, but this has not been put in place. Well, the protocol is in place, but its application has a lot of challenges because of the way partner states are behaving. And because of that, for us now as members of this motion, concerned and annoyed with the delay in the implementation of our motion, we want to take the community to court, to the East African Court of Justice, to have this matter addressed. Otherwise, we are not going to sit and just be counted as members of EALA when our people are suffering and they are not trading and they are not moving freely as they would have done.
Okay. Yeah, and the reason why you find the East African is extremely angry is because of the poor nature in which the constitutive instruments for cooperation were established by the architects of integration of the East African community. They have done it in such a way that when they established the East African Community Treaty and accordingly came up with the Common Market Protocol that gives freedom for establishment and movement, again they established substantive annexes that appear in a way to be antagonistic and oppugnant to the very process of cooperation itself. A case in point would be, for example, when you look at freedom of establishment, freedom of movement of persons, that clearly would have entailed a great intent for those that would want to work within the EAC. But then the annex, and particularly Regulation 15 of the Annex 3 to the protocol, again creates estoppels in such a way that the application is guaranteed. It grants almost partner states to manufacture their own applications in such a way that, first of all, the process is extremely rigorous. The process of application is rigorous. The fees are equally guaranteed under the annex, and that now creates a very big problem for those East Africans that would want to move the length and width of East Africa, to the extent that now partner states have started adopting bilateral agreements with which they are now waiving application fees for work permits. Now, when you go to Kenya, because there is a bilateral agreement between Uganda and Kenya and Rwanda and Kenya in terms of waiver of application fees, now the process of application itself is extremely meticulous. It takes a lot of time. It is extremely, it does not make it clear now that you can access that work permit as quickly as would have been contemplated under the circumstances of cooperation. So, in my opinion, I think going to court will solve much in such a way that we shall interpret all of the substantive documents that are arranged in tandem with the treaty as whether or not they reflect the Article 5 of the treaty that creates the objective reasons that made it a logical necessity now for the 6 countries to cooperate. That question now court needs to especially where now it becomes abusive when they establish the principle of variable geometry. It is now subject to a lot of abuse. That substantially as a way of policy, the EAC integrating entities take a decision. But that application and the commencement of application of the principles agreed upon then, each partner state now adopts the same as and when they please. That again is anti-integration. So for us as members of the Assembly, in the whole East African community, we are the only ones that were elected to foster integration. The rest of the leaders were appointed to run their own partner states. Whether summit, whether council of chairpersons, we are the only ones that are elected. And in my view, we must be the protagonists of integration now. That must be the new focus of East Africa.